There were numerous phone calls. There were 71
that you never
texts.
took.
We spoke a lot, 3 times a day at least.
You spoke 3 times a day?
Minimum.
So she's lying when she said that she only spoke to you twice?
At minimum 3 days.
Because
3 times a day.
all I see is text messages, and she's the main one sending them. You're responding with, okay, or I've got to take an exam. You don't really respond. So I really find it hard to believe that you're really taking her calls.
I take every single call.
Is that true, ma'am?
No, it's not true.
So you took 3 calls a day? Is that what you said?
Minimum from her.
Okay.
During those 3, from the 8th, the 9th, and the 10th, and the 12th.
What were the conversations about?
I sent documentation, I received an offer, I received a proposal. Can you talk to Mr. Miller? And that's when I realized it was getting beyond the scope. She was expecting me to make a phone call to the opposing attorney.
You know what you could have done when she reached out to you because of your ad? Hey, let's get on the phone. Tell me your problem.
She did.
Ma'am?
She did.
Can't take it.
She
Then that's when you should have made the decision not to help. It would have taken one conversation, not several, not 3 times a day, not 10 hours later. You would have had one conversation with her, and I guarantee you would have known, this is not something I can help you with. Not on some hope, not some optimism, but facts. But you took her money, and you spent it already. And I don't know if paralegals function like lawyers, but we can't do that. We have to earn that money. And you still haven't told me what you did for those 10 hours. If you could go off of one text and know this is too much, why would you need to go through hundreds of documents to know that this wasn't going to be the case you helped?
I did.
You did not what?
I did not go over those documents. The first page was depressive enough.
Okay, so what did you do for 10 hours?
The phone conversation, the text.
And ma'am, did you really think he was going to do all those things for $1,500? Do you know how many text messages you sent?
He said he was spiritual.
Spiritual?
Yes.
That doesn't matter in the court of law. Y'all know that, right?
And it was
I don't care what you believe in.
It was right up his alley, and he's done it several times.
You should have had a flag go up that this is actually way too cheap for all the things I need this man to do. And I know that you were in a very vulnerable position. You needed help, but this was not it.
Ma'am, all the documents I sent were already prepared.
They were already prepared?
I sent prepared documents for him to enter into court and review. And I sent him the evidence. He didn't have to dig or look for anything.
Then why did you say that he agreed to draft a request for order?
He agreed to because he looks at what I have and then he's going to draft it better. But, you know, I made the document myself already. It was pretty much there. He just needed to look over it.
Right, but I mean, you have to understand, I mean, you sent like 70 or 80 text messages within 24 hours, 48 hours. I mean, that's hugely expensive for a legal professional, for an attorney. For $1,500, you're not getting someone who's going to be responding to 80 text messages.
He given me no information.
Right.
He given me none, and he told me that he had an exam. Then he told me he had a flu for 72 hours. I was just trying to get across because I couldn't get him on the phone to tell him things that could have taken 5 minutes, but I had to say it in text. It took a long time.
All right. Did you end up having a hearing?
I never got to hearing because I never got my information in on time.
What ended up happening?
I had to hire somebody at the last minute. I had to scrounge up some money because he wouldn't return my money, and it was just too late, I believe, for them to catch up and do the job. Even though they were attorneys and they said that they would do the job, they did not do the job. And they admitted it, too.
But what was the result of the hearing?
They didn't get the evidence. They didn't get the brief in on time or the discovery. Okay. I had wasted a week and a half waiting for Miguel, and I didn't have the money.
You can't tell somebody that you're going to give them their money back just to get them off the phone. That's not good business practice. You can't do that. You're lying. I just don't appreciate your business practices. I just don't. I just don't.
All right. Are we good?
Please.
The parties are excused while we deliberate in this matter. Thank you both very much.
Ms. Agremont, Mr. Centeno, we have deliberated and reached a unanimous verdict. Mr. Centeno, you can't continue to operate the way that you operate right now. It's against the law. You cannot take money from a client without a written fee agreement. That is the purpose of a written fee agreement, is that you both have to understand the scope of the services being provided. You knew, we knew. The plaintiff didn't know, unfortunately, but she's the one without the experience in the legal services system. This was just not a task you could really attack. She was expecting far more help than you could or would be able to provide. And optimism is not an excuse for taking her money. Regardless of whether you spent the time or not, it doesn't really matter. You're not entitled to keep the money. So, Ms. Agremont, we find in your favor in the amount of $1,500, the full amount requested. Just know moving forward, these are terribly complicated and difficult and important issues in family court. And a document preparer is not going to be able to tackle a case of this complexity for you.
Thank you.
The verdict of the court is in favor of the plaintiff for $1,500.